we've been praying for this day for a long time. So I just want to say, angels watch over you guys and turn on those blue lights tonight.
Breaking news today, the jury in the Darrell Brooks case finds him guilty on all 76 charges against him, including 6 intentional homicides. Just one of those results in a mandatory life in prison sentence.
Deliberations lasted less than 4 hours combined. The jury started around 8 o'clock last night, and then they resumed deliberations this morning for another 2 hours. Last November, Brooks drove his SUV into the Waukesha Christmas parade route. He hit and killed 6 people, and dozens of others were injured.
Brooks was arrested later that day. Initially, Brooks' attorneys pleaded not guilty due to reason of mental disease or defect, but that plea was later changed, and Brooks no longer wanted an attorney. Following the reading of the 76 guilty verdicts, the Waukesha County District Attorney spoke with reporters.
Charlotte DeLeste is here with what Sue Opper had to say today. Charlotte?
Well, Susan and Mark, DA Opper says she's quite satisfied with the verdict and hopes everyone can now move on. If you followed the trial, you saw the many outbursts Darrell Brooks had in court while representing himself. Opper says legally it changed her team's strategy in terms of making sure Brooks didn't make a mistake in court and therefore get a new trial. Every night, her team would reevaluate based on his antics of the day.
He did everything he can except claim that the dog ate his homework. And he tried to turn this into his story. Let's talk about Mr. Brooks and his family. And we just kept redirecting it back to the real focus here is our families, our victims, our community, and his responsibility for this destruction.
In the end, DA Opper says their case was based on a thorough investigation with solid facts and video evidence to support it all. DA Opper says her team made a vow from day one to not put any children on the stand, saying there were plenty of other ways to tell this story without a child having to relive this tragic situation.
Charlotte, thank you. This trial has taken over 3 weeks, and there is a lot to break down.
Earlier today, Mark and I talked to criminal defense attorney Chris Van Wagner to get his take on the verdict.
What does an appeal process look like for Darrell Brooks?
Well, it looks really long and really complicated, to put it bluntly. The appeal doesn't begin until the sentencing occurs. And the sentencing, in this case, will be in 2 parts. The 3 parts, really. The first part will be today on the first 3 homicide cases. The judge will declare that he is sentenced to life in prison, but then she will set a hearing date to determine his parole eligibility, because on a first-degree intentional homicide, that's how it works. You get an automatic life sentence, but then you are told how long you have to stay. And the judge can say no release, and she can do it on every individual count. At the same time that sentencing occurs, she will have ordered the preparation, I'm sure, of a pre-sentence report, and will then sentence him on all the non-first-degree homicide counts. And once that is all done, then and only then he has 20 days in which to file a notice of intent to pursue an appeal.
And since he's acting as his own attorney, how does that complicate things?
Well, we've witnessed how it complicates things over the past 3 or 4 weeks. I would expect that the court would direct the public defender to appoint counsel for him. Appeals lawyers play a different role than trial lawyers. Trial lawyers have to sit with the client, have to talk to the client, have to go through witness information, fact information, and so forth. An appeal is literally based on the cold record. And so it will take probably, 3, 4, 5 months to just prepare the transcripts from the trial alone. So his case will not even reach a briefing stage for a full year. But the lawyer representing him, appointed by the public defender, no doubt, will also have to investigate whether there are claims. This is going to sound strange. The lawyer can actually claim ineffective assistance of counsel to himself, as crazy as that sounds, and can claim that he didn't get a fair trial in the interest of justice because he should not have been allowed to represent himself. That seems to fly in the face of common sense and logic, as well as Mr. Brooks' wishes, but I have no doubt that will be considered. There may also be evidence that because he represented himself, he was unaware of, and the appeals lawyer may find it and may add that to the claim, because in Wisconsin, before you go to the appeals court, you first have to file a motion for a new trial if you intend to seek it on any grounds. So I would say that we should not expect to know what his claims on appeal are with an appointed lawyer for at least a year.
He didn't do himself any favor during this trial, did he?
That is the understatement of the year. He did not do himself any favors. He did himself a lot of disfavor. And I hate to say it, but that is his constitutional right. There's an old saying. It is that a person who represents himself has a fool for a lawyer and a bigger fool for a client. And I'm not calling Mr. Brooks a fool, but I'm saying we witnessed live on a daily basis exactly why the client suffers when they don't have a real lawyer, when they represent themselves. There are some people who can pull it off. You may not know this, but I think Teddy Bundy represented himself in his own trials. He was a very smart man, but he still didn't help himself. So as a practical matter, Mr. Brooks chose the path he went on. Some people would say he basically broke himself into prison on this one, even if he had a chance of winning any counts. And the best an appeals court lawyer can hope is to raise questions that would allow it to be retried with the approval of Mr. Brooks as well, with an actual lawyer representing him that might be able to argue for something less than first-degree homicide. Because, frankly, that would have been the defense attorney's tack, that these were crimes of passion without either the intent or the premeditation that one normally associates with first-degree homicide. These were crimes he committed, it appears, out of anger and rage toward the girlfriend who testified. So a good lawyer would have tried to raise that and defeat or chip away at the state's contention that as he drove through that parade, he intended to kill people in a rage. Well, we've all heard the term blinded by rage. That appears to be what he was. And then afterward, he realized what he'd done, and he made efforts to cover it up. That doesn't mean he'll get any less time. People should understand that even if he's convicted of first-degree reckless homicide by a vehicle, which is, or second-degree homicide, whatever a lesser charge would be, if he had been convicted of those things, I suspect the judge would still give him a sentence that would be long enough that he would never see the light of day. I expect that to be the case here.
So it's far from over.
I would say that the main event is over. And I would say the likelihood of a new trial on appeal is only slightly better than the average case. And that's only because he chose to represent himself. But remember that you have a constitutional right to represent yourself. The judge had competency evaluations saying he was not incompetent. He understood the process. And so the judge did everything she could in a show of patience that I would say is unrivaled in my 41 years of practice, to make sure that she did not let her emotions get in the way. I would say that the vast majority of people watching this online or on TV probably felt like it was time to gag him and bind him and keep him out of the courtroom. She tried every single session of court to treat him with human dignity and have him return the favor with behavior. He, towards the end, decompensated. He fell apart. That's hardly shocking.
Chris Van Wagner, thanks for your insight. Interesting trial.
Great to see you, Chris. Thank you so much.
I'm glad to be of help. Let me know when I can do it again. Thank you.
And there are obviously a lot of layers to this trial. If you'd like to see our coverage throughout, check our website, channel3000.com, or download our app.